And now, Deep Thoughts with Judge Middleton.
In English into Cambodian.
I'm sorry, is this for legal purpose?
It is, but we're going to have to make do with what we have. So do you swear to the best of your ability you will do that translation?
I'm sorry, I have to transfer this call to a legal interpreter because I'm a medical interpreter.
I'm willing to accept that because that's all we've got. This is a misdemeanor matter that's going to be, I think, resolved, and I don't want to make this gentleman have to come back. So even though you're not a legal interpreter, I'm willing to accept your services. Do you understand?
I'm not allowed to interpret for legal service, so I have to transfer to a legal interpreter.
Okay, all right.
Yes, please wait a moment.
At this point, I'm willing to take what I can get, but they've got their own rules.
I'm sure she would lose her certification.
Well,
Good morning. This is the customer agent. I understand that you need a legal qualified Khmer interpreter
correct.
from Cambodia. Thank you. Please hold for the next legal qualified Khmer interpreter. One moment, please.
No?
It's the only language, sir, right? You don't have any alternative language?
That's correct.
Thank you. Please hold for the next Khmer interpreter.
My kids gave me a book for Christmas a couple of years ago called Babel. Or Babel. About languages.
Yep.
And there are 18 languages. And the first chapter is about Vietnamese and Cambodian. And after I read the book, I realized how ignorant I am.
What is that?
Because I barely speak one language.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm Phil, and Judge Bryant does it again. Please mute your device, sir. Please mute your device, sir. Please mute your device, sir. She is constantly being disrupted. And then she reminisces with the defendant of how he is known across all of the courtrooms as a bit of an a-hole. Then we find ourselves in Judge Boyd, and once again, she's not talking about fruit stripes, but she is just amazing. Her tone, her fairness, and just her court presence sets a standard for all other courtrooms. That's why I focus on Judge Bryant and Judge Boyd so much. But I do get a lot of hate in the comments towards Judge Bryant and Judge Boyd, but to each his own. So let us know in the comments how you feel. Also, in Judge Wagner's courtroom, we have a woman who does not know her place. But don't worry, Judge puts her right where she needs to be. And finally, Judge Washington deals with a mumbling, stumbling defendant who can't seem to say anything. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the daily docket. Court is now in session. Let's roll, nerds.
I said we back, huh?
Sir, can you stop talking? Sir, can you please adjust your camera so that we can see you clearly? Sir, can you turn your camera around so you're not sideways? All right, I'm ready on Anderson. This is case number 205655401, the people of the state of Michigan versus Corey Wendell Anderson. The defendant is charged with 1 count of disorderly conduct. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ivan Land, P65879, appearing on behalf of Corey Anderson, who's present on the screen. Your Honor, we have no objection to holding these proceedings by Zoom. Thank you.
You're welcome. Did you say your P number? I'm sorry.
Yes, P65879, Your Honor.
Mr. Anderson, please unmute and state your name.
Anderson.
Please state your name and turn off your devices. State your name again, please.
Corey Wendell Anderson.
Today is the date set for an arraignment on a bench warrant. Mr. Land, as to the arraignment on the bench warrant,
We stand mute, Your Honor.
court enters a not guilty plea. It appears that Mr. Anderson actually capious from a review that he is on probation to the court. Whoops. That his probation officer is Lori Bumpus. And that he was placed on probation by me, October the 21st, 2020. He is going to have to turn off his other devices.
Okay.
He was ordered.
Yeah.
Sir, what is going on? Let me come up. I'm gonna need you to be quiet. I'm gonna need you to make sure all your devices are turned off. Okay. I don't even know what this means, conservation, restitution. I have no idea what that means. They must have, somebody typed that in wrong, because I don't even know what that means. But his total fines, cost, and fees look like it was $1,020. It was delayed under 771. It's no longer delayed under 771. He was given 3 days credit for time served in jail. I said I would consider an early review after 5 months. And then that was in October 2020. And then he was supposed to come for review in March of 2021. He failed to appear. A bench warrant was issued. And then some kind of way he made a payment, even though it should have been, he had an arraignment on the bench warrant in 21. And then I said he must have started his probation and paid some money by July 14th. When July 14th came, he didn't come. So then he's been in warrant status since July 14th.
Your Honor, so are there new charges of disorderly conduct, or this is just a probation violation?
No, this is just a probation violation.
In the original charge was it the curfew for the COVID?
It was something.
Yeah, Your Honor, so I can explain about my client. So my client, in his defense, he lost 7 family members to COVID, and it was after a funeral. Police came past the curfew. I know a lot of judges didn't like that particular law, but it was a law, Your Honor. My client is I
wasn't one of those judges.
Yeah, I know, Your Honor. Outstanding guy, Your Honor, helps people around the community.
Well, why did he go missing?
Your Honor, he's under my watch now. I can't answer that. I know his family. I've been knowing his family my whole life, Your Honor. Let several tenants that could not afford their rent. He didn't try to get the Sears money or anything. He didn't try to evict them. Outstanding gentleman. And I heard this court state that they would remove his 771.1, Your Honor. I would ask that the court not do this. My client can make the full payment of anything he owes today, and he would ask that this matter be closed out, Your Honor. He's not a bad individual, Your Honor. But I did explain to my client, I know COVID was tough on everyone, lost a family member, had a disagreement with some police officers, Your Honor, and he's before this court, which I told him, I know this court is very fair, but if he must obey the laws of this court, Your Honor, and he does apologize. And, as far as his cell phone, Your Honor, he understands that he needs to turn it off, but he has a lot of, I would say, elderly clients. So he actually sleeps with his ringer on and forgot to turn it off, because he really does help the community, Your Honor. I know it doesn't sound like that the way he fails to appear in court, but Your Honor, I would ask for you to give him the benefit of the doubt and allow him to keep 771.1 and just close this matter out, Your Honor.
I have to tell Ms. Stevenson sometimes, I said, "Ooh, if I could have my eyes closed and just hear what the lawyer says about their client, that would probably go a long way." But it's not the fact that he had the phone on, it's the fact of how he responded when I said he had to turn the phone off. Right. And right there, like it just don't be necessary, right? It's not necessary. So what I did was recite everything that was taking place in the register. That's all I did, was recite it.
Yeah.
And then, because the law says that if a person, the sentence can only be delayed for 12 months. So that's where we mess up, when we don't come back to court in the 12 months. That's not my fault, that's his fault. The law said 12 months. You gotta delay the sentence within 12 months. And if it ain't in 12 months, then it's no longer delayed. Now, it appears that he already paid the money.
Okay.
It looked like he has a zero balance.
Okay.
Looks like he already paid the money. Looks like the great man that you speak of just needed to come to court. That's what it sounds like. Now, he paid the money after the 12 months. He paid the money after the 12 months. Let's see. Looks like he paid the balance. Let me go back up. When did I put him on probation? Maybe not. Let's see. Oh, and he was supposed to do 5 days of community service. So he was supposed to do 5 days of community service and pay the money. He paid the money and he didn't do the 5 days of community service. But let me see when he paid the money. That's when he came back to me in 21, and I said he needs to have that money paid, some money paid. Then he did pay.
May I interject when you allow me, Your Honor?
Mr. Flanagan, what does conservation restitution mean?
I'm looking at that too, Your Honor. That must have been an old entry code or something, because I've never seen that before.
Okay. So then I'm looking at May 4th and it says credit card tender. That means he paid $720, right?
Yes.
Okay, and that was before the thing. And then his balance today is 0, right?
Yes.
Okay. Yes, Mr. Land.
Your Honor, and I'm not trying to be snotty, but you are the boss, Your Honor. I really don't care what the law says. You can do it, Your Honor.
I would never do that, Mr. Land. I would never do that. Let me
You
say
are the boss,
something.
Your Honor. I know they
I
have
am
laws,
the-
but
I'm the boss. However, I'm the boss and I'm in the judicial branch, and the legislators are the legislators and they make the law. Whether I agree with them or not, it is my unless I believe them to be constitutionally in error, it is my obligation to follow them. Now, that being said, it appears that Mr. Anderson did actually pay the money within the 12 months. He had a 0 balance. He doesn't, I don't know what happened to the community service, but I just have a good feeling that he didn't do it. But let me just say this, and then I'm gonna tell you my decision.
okay.
Yeah, I wasn't one of those judges who didn't like the curfew, because y'all should have had your hand parts at home. It was stay home and stay safe. And then we talking about everybody dying from COVID, and I am so sorry for his loss. I'm sorry for the loss that I suffered. I'm sorry for the loss that you suffered. But if we were staying at home and staying safe, some of us wouldn't have been suffering the loss. And so I am one of the people who took that order very seriously and was irritated at the people that was out in the park and stuff, partying and all of that. So having, trying to make sure that my elderly loved ones were safe and not infected, and all of that, I stayed my hind parts home and I stayed safe. And I lost some people, not in my family, but people who were very near and dear to my heart, because people wasn't staying home and staying safe. But having said that, I am willing to waive the community service because I have a feeling he didn't do it, and I'm not going to even check and see, right? Because I have a good feeling he didn't do it, because he was gone. He'd been gone all that time. He did pay the money. And additionally, I already had given him credit for 3 days. So when I sentenced him, I must have been really feeling real strong about the fact that y'all wasn't staying home and was arguing with the police when they was trying to get you to go home. It don't matter if somebody is deceased. Don't matter if we were out at the funeral. It doesn't matter that we were grieving at the time. If the people told you to go home because it was a curfew, go home. Go grieve on your front porch. Go grieve in your backyard, but get off the city streets. So I don't know. I must have been feeling real strong because I gave him community service and credit for the 3 days. So I'm going to take away the community service. He has the credit for the 3 days served in jail, and he paid the money. I am going to therefore honor the delayed sentence because it was completed within the 12 years, not because I'm the boss and the most important judge in the whole world, but because he completed it during the time that the legislators have set for him to complete it within. So we are going to close Mr. Anderson out of this probation. I will honor the delayed sentence. I will dismiss the matter with prejudice, and I will set aside the conviction. Mr. Land, if you could send that dismissal to the clerk, dismissal with prejudice to the clerk, and then I will have probation submit the order of discharge. Anything further?
Always a pleasure, Your Honor. Thank you so very much.
Always a pleasure. And
Take care, Your Honor. Stay safe.
It's good to see you still doing this.
Yeah. The big
All
day,
right.
the big day is in 2 days, so
Oh,
you know,
really?
yeah,
Yeah,
yeah, so,
I understand. I
yeah.
definitely understand. All right, well, you take care and be strong, okay?
I see you got your APA looking like a movie star.
That's her, but oh wait, what happened to he must have made a mistake and pushed delete soon as he said that. I was gonna tell him, no, that was you. You, that's your Beyonce. Look. All right, Mr. Anderson, we'll mail you a copy.
McDuffie?
Your Honor, that hearing would be held in this court or 14A1, since that's where he took the plea. But other than that, I mean, I can't really stop him. I'm trying.
It would occur here because
Okay.
this is where it is now. This is who has the jurisdiction. If I decided to allow that, which there needs to be an opportunity for Ms. McDuffie to respond. So I'm going to schedule it for, what is that noise? Is someone hammering?
Adjournment until this find out what's going on and about the 7th on the case of the drunk driving case. How you doing, Simpson?
I'm doing great, Bailey. You all right?
No, I'm not. Mr. Simpson, can I speak before sentencing? I lost
Mr. Bailey,
Okay,
Mr. Bailey. Today. It's probably better you don't start talking to me about anything, okay?
I just want to show you a picture I drew you. If you give me a second. Okay, I'm in a lot of pain. Okay, I drew you something. If you could just take a shot. I drew, okay.
You drew me.
I put your name on it. That's for you.
That's for me.
Yeah, that's an old school car for you. I did put you some spinners on it.
All right, so I'm like an old school car.
Oh, well, it's you know what I call it?
Judge, I believe he's calling you a classic.
Yeah, it's old school.
Okay.
Okay, I done lost 7. I got to get 7 more piranhas. They're all floating in the fish tank.
Okay. All right, Mr. Bailey. We'll see you on the 24th.
The 24th?
Yep. Okay.
Okay.
Take care. That way they'll talk to you before then. Bonds will continue. Thank you.
The 24th of this month?
Yes, sir.
Okay, thank you.
All right.
Okay.
On behalf of Mr. McIntyre.
All right, so where are we on discovery?
Judge, just to let you know, there's a pretty much of a mountain of, there's 7 boxes.
Okay.
Not necessarily all the case in chief, I guess, I mean, the actual event, but there's several different letters and other things that I've talked to Mr. Jerry Goldstein, that is part of the defense team earlier or yesterday. I know he's out of town along with John Hunter, who's having his first child or second child, I believe, or his wife is rather.
Okay.
And so I am in conference with them. So discovery is still not up to spec yet. So
Calm down, please.
I
Please be taking photos. Step outside, sir.
I think another setting.
Oh, just one second. Who's taking photos?
This gentleman right here, sir.
Excuse me, could you all divide a little bit? Who are you?
My name is Gabe.
All right, and why are you taking photos in the court? No, my question is not, I'm sorry. My question is, why are you taking photos in court?
I was just being foolish.
All right. And what's your full name?
My full name is Gabriel Gobert.
All right. Do you have any cases pending in this court?
I'm here for MTR court date.
Could somebody look him up and see if he has a motion to revoke?
He does. That's current witnesses.
All right. So who are you taking photo of? Without their permission?
Yeah, I'm sorry, I shouldn't have.
No, who?
Nobody else.
No, you're gonna show your phone to the deputy and you're gonna erase that photo you took. Do you understand?
Yes.
Sorry about that. All right, so if
I'm sorry, I have a problem. Can you hear me now?
I can. Please state your name.
Dennis Duff.
Thank you. All right, we're here for a plea agreement today. Can you please place the plea on the record?
Yes, Your Honor. The agreement is to plead as charged to OWVI.
no contest.
No contest. I apologize. With an agreement to, I believe that was non-reporting probation.
Did I say that?
I believe so. I can certainly double check my notes.
Well, Mr. Duff has, let's see, we just did a violation, or his last violation report was dated on July 26th. So I'm not sure that I agreed to non-reporting probation.
I believe it might have just been straight to 12 months probation.
Yeah.
Yeah, that was it.
Okay.
All right, Mr. Duff, was that your understanding of the agreement, sir?
Yeah, I guess, ma'am.
So you want to proceed with the plea today, sir?
Yes, ma'am.
All right, thank you. All right, my understanding is you're going to be pleading no contest. Is that what was just said?
Yes, ma'am.
The operating while impaired, that is a misdemeanor carrying a maximum of 93 days and up to $300 fine plus court costs. With the agreement that you have, was it 12 months of probation?
That's correct.
All right, sir, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may. I'm gonna go over some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you need to speak with your attorney, okay?
Okay.
It's my understanding that you, I'm sorry, you have the right to have a trial in this matter by a jury and you're scheduled for jury selection tomorrow. It is up to you, sir, if you choose to enter into this plea. You have the right at that trial to call witnesses to speak for you. You have the right to question those witnesses and any, I'm sorry, you have the right to hear, see, and question any witnesses that are called by the prosecution. You have a right to get an order signed by me to request that your witnesses come to court if you want witnesses to come to court. You have the right to actually testify yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, ma'am.
All right. Do you understand you're gonna be giving up all of those rights and you're not
Yes.
gonna be on trial of any sort?
Yes, ma'am.
Do you also understand, sir, that this is not something that you have a right to appeal, and therefore in all likelihood, this decision is gonna stick with you?
Yes, ma'am.
You also understand that if you were on probation, parole, or bond on the August 3rd date of 2022, when this was allegedly occurring, and you still are, that you can be in violation of either of all or all of those.
Yes, ma'am. I wasn't on anything, so.
Okay, good. Thank you for volunteering that. Do you also understand that if you're not a U.S. citizen, you could have immigration consequences?
Yes, ma'am.
All right. To the charge of operating while visibly impaired, how do you plead?
No contest.
Anyone promise you anything to get you to plead no contest?
No.
What's the basis for it, Mr. LeBeau?
Potential civil liability, Your Honor.
All right, I find that that's an adequate factual basis for the plea. Mr. Duff, anyone threatening you to get you to do this?
No, ma'am.
Anyone make any promises that we have not placed on the record today?
No, ma'am.
All right, thank you. I am going to find the report here in 1 second. Did that one get sent to me?
Mr. Lebo?
I will send it at this time, Your Honor.
Please send it to both myself directly and to Miss Akiri Akinruli so that I can get it as quickly as possible.
Certainly.
Which did you call me?
Directly.
Ian was like,
Yeah.
So that's why.
I mean, oh, I'm sorry. No, I meant Miss McDuffie. Sorry. The prosecutor is who I meant.
I thought you meant Ms. Ball.
That's what I thought as well, Your Honor. But in any event, I'm emailing it to all three.
Thank you.
And it is now sent.
Even after I receive it, it'll take a minute with our new system to allow me access to it.
Yeah,
I do have it, but it's still on the scan.
Unfortunately, I'm aware of that as well.
Okay.
Yes.
All right, I'm in receipt of case report number 220061-523 with the date of incident of August 3rd, 2023 at the vicinity of Bridge Road and Textile Road in Ypsilanti Township. Do the attorney stipulate to my use of this report to determine the factual basis?
Yes, Your Honor.
Likewise, Your Honor.
McDuffie.
So, Your Honor, pretty much the beginning, the first page of the report, which is on page 4 of the narrative, and then basically down to the end of that section up through the pre-arrest screening, or up until the pre-arrest screening should be everything.
All right, so they were, the police were dispatched to this location at Bridge Road and Textile for a 2-vehicle crash. And there was a yellow Ford Ranger and a gray Fusion that was involved. They walked up to Mr. Duff and he acknowledged that he was driving. He turned on the textile and turned too far and crashed into another vehicle. Based on their suspicions, they ran a test, and the lab report shows that there was methadone and ramazolam detected. And
I think just 1 nanogram of THC in addition to that.
okay.
And for the record, I would note that bromethylene is not a controlled substance.
I'm sorry, what did you say, Mr. Duff?
No, I'm just mumbling. I'm sorry.
Um, so, I'm sorry, am I muted?
No, you're not.
I am not muted, that's good to know. That's a benzodiazepine, Mr. Lebo, so I guess
I just want to note for the record that it's not scheduled under Michigan law. I don't know if this is of any relevance. I just want to make sure we're having it clear.
okay. In any case, I don't think that those are listed out in the complaint, but obviously the methadone is an issue.
I have a question real quick, if I could, please. Is it illegal to drive on methadone? Because I see people at the methadone clinic driving up and get their methadone.
Mr. Duff, why don't you give me a call about that after court?
Well, I can answer his question for him easily. It's illegal to drive with any substance that affects your driving, sir. And
So everybody that goes to the methadone clinic is breaking the law?
Mr. Duff?
Yes, ma'am. I'm sorry.
Mr. Duff, only one of us can talk at a time, and I was talking.
I'm sorry.
Okay, so if it affects your driving, then it is illegal. It doesn't matter what the substance says. It doesn't matter whether it's prescribed. It's still illegal.
Okay.
And so when you get into a crash, that shows that your driving was affected.
Right, but I mean, okay, I'm sorry. For sake of expediency, let's just keep it moving.
I'm satisfied that there's a factual basis for the plea. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Likewise, Your Honor.
Thank you. Sentencing in this case will be on September the 7th, 2023 at 10 a.m. Yes, sir.
I'm sorry. I'm sorry. I talked to myself. I'm sorry. I mumbled to myself. I didn't know you could hear it. It was nothing. I was thinking out loud. I'm sorry. No disrespect, Your Honor, please.
Did you write down the phone number earlier today, Mr. Duff? To the probation?
No, ma'am. I got a pen and paper right here. So can I get that, please?
734-483-7336.
483-7336. And that's probation. Okay.
Yes.
Okay, so I have to call them.
Correct. To schedule an appointment to have an interview done, an assessment. I don't know if he's had a recent assessment since he's on methadone. It sounds like he's under treatment right now, and maybe there's something that he has already completed. But in any event, I'll allow you, Mr. LeBeau, to follow up with probation regarding that.
Yes.
Okay. All right, I'll see you back here on September 7th, sir.
Okay, so I contact probation ASAP?
After 9 o'clock tomorrow, sir. Thank you.
Oh, okay. Okay, thank you.
You're welcome. Bye-bye.
Okay, all right. Yep. Sorry.
Yes.
You may lower your hand. Ms. Madden, you have ticket number P1452570, the People versus Jamie, Jamie, Madden, Maddan. Ms. Madden, you have 3 counts. Count 1 is driving unregistered motor vehicle. That is a misdemeanor. Count 2 is no insurance. That is a misdemeanor as well. And count 3 is drive without a valid license. That is a misdemeanor. The people have indicated if you were to plead to count 1, well, let me first ask you this, ma'am. Do you have, no, we would know that. I already checked.
Judge,
yes.
Judge White, I've been here with you probably numerous of times, and every time I take care of a ticket, the state of Michigan says that.
Ma'am, you
From my phone.
You're talking. If she unmute one more time, I don't know.
I cannot receive a driver's license. Like, I'll have no tickets, and I'll go the 2 years without any tickets, and and the state of Michigan will not offer me a driver's license.
Ma'am, that's nothing I can do about, that's the Secretary of State, and I don't know what their rules are or what they're looking at. But ma'am, just in you saying that you have been before me several times means you keep getting tickets.
Yes.
So if you keep getting tickets, that might have something to do with you not getting a driver's license. So if you're seeing me, that means you have tickets. So maybe you get this straightened out and then go to the Secretary of State and say, I have no tickets now, and I'm not picking up any. Well, ma'am, what I'm telling you, that is not a court issue. That's a Secretary of State issue. And there's nothing I can do about that. All we can do is take care of your tickets.
Everybody keeps saying that, like the last time I was here seeing before you, this was when you got reelected. This was in 2020. I waited the 2 years and tried to go get my license from the state of Michigan, and they say no. So it's like I still have to go to work and everything. Like it's like I'm in a lose-lose situation.
Well, ma'am, like I said, there's nothing the court can do about that. The Secretary of State is a separate entity with their own rules. So maybe you go back. Do you have any other tickets other than this? And the other thing, ma'am, I only see what you have in Detroit. I don't know what you might have. I know, ma'am, let me finish. I don't know what you might have in any other city in the city of Detroit. It could be Highland Park or Southfield or Saginaw or Lansing. They do the entire state. All I see is Detroit. So if you take care of these tickets, I don't know what else you might have. So all I'm saying is, if this is all, and you know what you have, if this is all you have and you don't have anything else in the state, then go to the Secretary of State and say, I've cleared up all my tickets. What do I need to do? Because they can tell you that to get a license. I can't tell you. I don't know. Well, it's nothing I can do about that, ma'am. I'm not the Secretary of State. So all I can do is help you to clear up the tickets that you have.
If I can interject, excuse me, if I can interject here, there are programs that the court puts on sometimes that, or organizations put on that help people get their driver's license or driver's license restoration clinics. And also I've heard that they have a couple vans in Detroit that go around and find people in different areas and help them get their driver's licenses. So if you look it up on the internet, you can get help. So that'll help you to get your driver's license.
So what are you suggesting that she looks up? Driver's license restoration?
Restoration, yes. Then it'll pop up Detroit, and it'll there'll be leads that'll pop up there that because I worked in one of those clinics a year ago or so, or 2 years ago.
All right. Well, ma'am, he's giving you a lead, so you go ahead and do that. Just make sure whoever you go with, just make sure that they're legit. All right. So it's not somebody that's going to take some money from you. So. You got that, Miss Madden?
Yes.
All right. So now for today's tickets, you wanted to take advantage of this offer, ma'am?
Yes.
All right. All right, Ms. Madden, you understand that you have a constitutional right and absolute right to go to trial, but if you plead guilty on any of these matters, you give up that right. You understand that?
Yes.
All right, Ms. Madden, the people of offering that you pled to improper plates, count one would be reduced from driving an unregistered motor vehicle to improper plates, lower charge. The other two matters would be dismissed. Are you pleading to that, ma'am, because you are in fact guilty?
I thought I pled to not having no driver's license.
No, ma'am. They're dismissing that charge. That's a higher charge. They're dismissing that charge. They're dismissing the no insurance, and they're reducing the drive an unregistered vehicle to improper plates. So they're dismissing the license.
The car is registered. The car is registered.
It was registered on that date, ma'am, on April 26, 2023.
What you shaking your head for?
Who are you talking to?
Head for?
Ma'am. First of all, people can do anything they want to do. You don't get to check anybody in my courtroom. You deal with me and with me only, ma'am, because I'll put you out. We are not going to get into a Zoom fight with someone. So you deal with your case. See, you don't know what's going on in his house or in his place. He may be dealing with somebody in his family. He can shake his head any way he wants to. You deal with me. You say something else to somebody else in this courtroom, I'm putting you out. and we won't deal with your ticket today. Now, do you want to take advantage of it? I asked you, are you pleading guilty because you are guilty? Were you, the vehicle you were driving on that date, was it registered at that time on April 26, 2023?
No.
Court will find you guilty of the amended and reduced charge of improper place. Your fine will be $225. The other two tickets would have been $225 each. So that's $450 that's being dismissed. Your fine $225. Do you need time to pay that, ma'am?
No.
Okay, if you can pay it right away, you know how to pay, then you're all set. Do you understand, Ms. Madden?
Pardon me?
I said your fine is $225. You said you do not need time to pay it. You're just going to pay it. And if you know how to pay, you're all set. You can sign off. The other two matters are dismissed.
Pay it when? Today? I can pay it
No,
right now.
ma'am, I asked you, do you need time to pay? If you needed 30 days or 60 days or 90 days, I could give you time to pay it. You said you do not need time. If you don't need time, you can pay it anytime this week. Pardon me?
Okay.
Do you need time, ma'am?
No.
Okay, then you're all set, ma'am. You can sign off. Good luck.
For sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Alan Applebaum on behalf of Mr. Davis.
Your P number, counsel.
36444.
And Mr. Davis, your name for the record, your full name. Unmute.
Michael Anthony Davis II.
Thank you. Today is the date set for sentencing. I've had an opportunity to review the pre-sentence report, but I think this was a case. Remind me, is this the case that Mr. Smith was handling at first?
Yes, Your Honor. If the court recalls, my client took a plea in front of Judge, it was Judge King. I forgot. It's in front of, I have the transcript here, but he took a plea in front of another 36th District Court judge. At that plea hearing, Your Honor, my client had met with Mr. Marvin Smith, who was attorney at the time, and the assistant prosecutor at the time. And my client believes that they made an agreement that my client would plead guilty to the charge, immediately pay the restitution for the items that were allegedly damaged, and then probation would be immediately canceled, I guess, if that's the right word. Yeah. The matter transferred to you, and then at a hearing.
Okay, go ahead, counsel. I'm sorry.
At a hearing a couple of months later, my client, you had indicated that you thought that you might not give that type of sentence because you had not taken the plea and you were not part of that agreement. I had indicated that my client had indicated to me that that agreement had been placed on the record in front of the other judge. I did purchase a transcript, Judge. I do have the transcript, and that was not. It was not really placed on the record.
No, it wasn't. I knew it wasn't. When he said that, I knew it wasn't, but go ahead.
I mean, basically, I can read to the court. It says here, when Mr. Davis said, I thought that this was, that was going to be the deal, the court said, all right, if I can't tell you what Judge Bryant is going to do, I can tell you what I would do in a case like this. If everything was paid off and you came for sentencing, I'd probably just close it out right then and wouldn't worry about it. So long as you can show it's paid off, your attorney can motion to have it closed out and probably will. But I can't speak for Judge Bryant, and that's where we're at. So you had indicated to my client that in theory you might, I repeat, you might allow him to withdraw his plea, but you wouldn't really make that decision until the transcript was secured and the language in that portion of the transcript provided to you. And so that's kind of where we're at, Your Honor.
Yeah. I knew it wasn't, I knew that didn't happen when your client said it. Why? Because I know that my colleague who came on the bench the year before I did knows exactly how it works. So when a plea is taken in the felony courtroom, it is automatically sent to the misdemeanor court. If they plead to a misdemeanor, the felony judge can only accept the plea and can never speak for the misdemeanor judge who's going to actually do the sentencing. So I knew that my colleague would not have told Mr. Davis what his sentence was going to be, because there would only be one person that knows exactly what the sentence would be, and that would be me. And then Mr. Davis's attitude was so horrible that day. I mean, it was so horrible that day. I remember it like it just happened yesterday. It was so horrible. In fact, when his lawyer came out of the breakout room, I knew that they had some strong words inside of that breakout room. And then his lawyer asked to be removed. And then Mr. Davis, he left. I think he came back, or he tried to come back or something. And his attitude was so horrible. And then I said, well, I would consider allowing him to withdraw his plea. And then I too read the transcript. And I knew that my colleagues said what he said. And Mr. Davis heard what he heard. And that's why it's a good idea to pay attention and to be cordial in court. Because then the judge comes back and remembers the attitude and behavior of the person who's asking the court to do something. And then the court is not inclined to do what the person is asking them to do, because the court remembers how horrible their attitude was the first time that they came. And I don't even think that we got to even what the terms and conditions of the probation would be, outside of the fact of me letting Mr. Smith know that this isn't some just pay and go. If a person maliciously destroys property, they got an anger problem. It's something else that needs to be addressed. This is a misdemeanor, and it is punishable at least by 90 days in the Wayne County Jail, and up to 2 years probation, up to $500 in fines plus costs. So, Mr. Applebaum, how did you want to proceed?
I'd like to ask Mr. Davis if he still wants to have the opportunity to withdraw his plea. I spoke to him this morning. I didn't. We wanted to see. We wanted to go to court this morning, and he's got. And I don't need, because you had indicated the last time you were not quite sure if you'd even allow him to withdraw his plea, but you didn't make a decision whether he could or couldn't at that time. I wasn't there when Mr. Smith obviously was there, and maybe Mr. Davis was, I'm not trying to make excuses, or maybe a little bit, but I think he was frustrated the last time because, right or wrong, good or bad, he was under the impression that he thought that was the deal. That doesn't make it right. That just means what was in his mind. So I think he was a little bit frustrated with Mr. Smith and or whoever, or maybe he should be frustrated at himself. That I understand.
For not listening when Judge King clearly said, I can't tell you what Judge Bryan is going to do. I could tell you what I would do. And then that's why when he was on this docket, he was doing what he was doing. And then he wanted to be on felonies and I wanted to be on here, and we switched places. And now he can't tell me what to do and I can't tell him what to do. And that's why we're right here, right there.
But I wanted to get that transcript to show him, and he's absolutely read that transcript. So he knows. Okay. He understands.
All right.
So the question, Mr. Davis, is, and I've not seen the pre-sentence report, Your Honor, but Mr. Davis, do you want to go ahead with sentencing with Judge Bryant? Do you want to respectfully ask to withdraw your plea, have the felony charge reinstated, then back to the drawing board? That's, we've talked about it. You got to make a big decision.
Okay. Miss Bryant, Miss Judge Bryant. With all due respect, I apologize for being rude. I just felt like I was getting shambled by my former attorney, because what he took me out in the hallway and talked to the prosecutor about, yes, you're right, it wasn't put on record. But they clearly took me out in the hallway and say, take this plea and just pay this money, and I'm not going to look forward to moving forward and pressing any charges. And then go downstairs, pay the $1,200, and then everything will go away. And then so when the judge got to talking and then it got shifted, that's when I got upset. I wouldn't get upset about nothing else. I mean, I was mad.
Seemed to me like that would have been the appropriate time to ask Judge King to withdraw the plea. Seemed to me like that's why you say, has anyone promised you anything that was not placed on the record in order to get you to make the plea? But your anger was misplaced and it was misdirected and it was rude and it was disrespectful.
Okay.
And having read the transcript, I don't believe that the option of withdrawing the plea is an option. Judge King was clear. Judge King was clear, unequivocally. He said, I can only tell you what I would do.
Okay, and then also, Judge, I want like they sent the papers, it's in the transcript that they sent the papers downstairs for me to go pay. And also Mrs. Smith filed a motion like a week later.
Couldn't have sent no papers downstairs for you to pay because Judge King cannot impose any sentence. So there was no sentencing. There was no sentencing. Let's be clear. There was no sentencing.
I understand that, but it's in the transcript saying that we are sending the papers downstairs for me to go pay. I stayed downstairs for an hour and the papers never came. I was at the window.
Well, there is some language, Your Honor, in the transcript regarding some paperwork going down to the probation department. But
probation, a referral to probation for a pre-sentence investigation.
I agree with that. That's what I believe.
Okay.
So I don't think there's any language in the transcript that talks about the agreement. I'm just trying to see here whether there's standard statements that are made before a plea is taken regarding promises and things like that. And it says, do you understand the rights? And you had an opportunity to talk to your attorney, and then you're waiving your rights. That was the standard thing. Anything regarding a promise of the sentencing, but let's see here. You're giving up your rights. You have a right to be presumed innocent. He goes through the standard subpoena powers. So I don't think there's any language in that transcript regarding whether any promises were made. Though when they got to the last paragraph on the last page of the transcript, Judge King specifically says, this is what I would do, but I'm not Judge Bryant, and she's got to make her own decision. And never was given an opportunity after that statement. It just went right to, okay, you're sentenced. You'll get your sentencing date and be on your way. So there's some frustration on his part, justified or unjustified, as to the procedure of what happened. But that's kind of where we're at, Your Honor.
Well, it's my decision is that I'm not going to allow the withdrawing of the plea.
Then, Your Honor, I haven't had a chance to see the probation report, but so I don't know what the recommendation is. I don't know if you want to give the people a chance to send that to me, whether you can give me the highlights over the phone so I can elocute on his behalf. But I did not get an email or anything in the mail regarding a proposed pre-sentence report. Now, maybe it was given to Mr. Smith, but I have filed an appearance in this case.
It probably was. The pre-sentence investigation is dated April the 12th, 2023. So it is the original pre-sentence report. We can send it to you and I can adjourn the sentencing, give you opportunity to go over it with your client. It's a standard recommendation. In fact, it's a little surprising to me of the recommendation for 12 months probation, since Mr. Davis has a previous conviction for aggravated assault. But nonetheless, well, I guess that's not a conviction. It's not.
Yes, Judge, is that probation reporting or non-reporting?
Oh, all of my probations are usually reporting, depending on what I order. There is a recommendation for anger management. And because of the way that Mr. Davis always acts when he comes to my courtroom, he definitely needs anger management. So there is a recommendation for anger management.
I hope he's presenting himself professionally this morning, Your Honor. He hasn't raised his voice. He hasn't seemed too frustrated. I think I
fashion myself a body language expert. That's a part of what I'm gonna do when I leave the bench. And every time I say something that he don't like, I'm from the east side too, 6115 Seneca. Every time I say something he don't like, he roll his eyes, he grunts, his nose inflects out, his mouth. I'm gonna make money helping people pick juries because I'm gonna watch the body language of the jurors. I fashion myself to be very insightful in that area. So no, he has not yelled and raised his voice today. No, he has not exhibited the behavior that he exhibited before. But it is clear to me that for whatever reason and whatever occurred between Mr. Davis and Mr. Smith, number one, he's not over it. But had he gone into the courtroom with Judge King and actually paid attention to what the judge was saying, we probably wouldn't have all this anger and stuff right now. But there is a recommendation for anger management. Now, there was a recommendation in my previous case for anger management. And then I said, well, I'm going to focus more on this area. So, Madam Prosecutor, is there any objection to me reducing that anger management? And then she said, no objection. Because that's the kind of judge I am. I'm a judge who believes in an individualized sentencing, right? I'm a judge that believes in looking at the circumstances and deciding the sentencing. But from what I see from your client, that recommendation for 12 weeks of anger management, it almost should be 24 weeks. That's what I see. But I probably wouldn't do that, but that's what I see.
So, Mr. Davis, you've kind of got an idea of what there's obviously there appears to be no recommendation of incarceration. Looks like 12 months reporting probation. There's going to be some weeks of possibly of anger management. Do you want to go into a breakout room with us, or are you ready to proceed to sentencing? Because you're going to the recommendation is not going to change, whether we delay it or not. And I think
it don't matter. I mean, Judge, listen, I didn't want you to take nothing the wrong way, this, that, and the other, but
No, these comments are not,
I have been through so much. I'm from the east side off 6 Mile Grass here.
Sir, can you hear me? Am I muted? Am I muted?
Oh, let me see. Oh.
No, I'm not muted. So at this point, I only want to know, are we proceeding with the sentencing today? And if we are, then Mr. Davis will get an opportunity to speak. But right now,
I didn't know that.
No. Is, are we proceeding today? Because I've been through a lot too. Yesterday was the anniversary of my sister's death, who died young after she suffered a stroke. I've been through a lot too.
Yeah.
They thought I had breast cancer. I've been through a lot too.
Right.
I was homeless. I've been through a lot too. We all been through a lot.
Yeah.
We don't come in here and take out our frustrations on the people who've done nothing to you. No, that's not how it works.
Right.
Now, I've been real patient. So, counsel, I'm gonna send you and your client to a breakout room. Then he could tell you if he wants you to go over the report in detail. I will give you an adjournment if you request it, because we did send it to Mr. Smith, and I'm sure Mr. Smith, perhaps he didn't forward it to you. So let's send you both to breakout room number 3.
I think Mr. Davis can answer that question.
Oh, okay. Well, because let me tell you another observation. Remember, I said I was observing, and this what and so there's a judge sitting in my office because she's going to help with my docket next week. So she had come in to just kind of watch and then so I go over the docket with her. She just came in after we started, and she got the same feeling about Mr. Davis that I have. She said she's from the east side too. She recognized all that aggression too. It's a lot of aggression going on with Mr. Davis. And so maybe he might want to wait. But I know how to separate. So are we going to sentencing today, or am I giving an adjournment?
Mike, you want to go ahead right now, or you want to get an adjournment?
No, please, let's adjourn it.
Okay.
Well, so yeah. Yeah. Can we adjourn it, please?
We're going to adjourn to Council, is 23rd a good day for you?
It is a good day. All I have is a 10:30 in probate court. But
Oh,
I'm
wait,
good.
wait, I apologize. Not the 23rd. Excuse me. No, I can't do the 23rd. The 25th, the Friday.
That's fine.
Okay, I can adjourn it to the 25th of August,
What time, Your Honor?
9 o'clock.
And what would be the procedure, if any, Your Honor, for me to get that report? Should I come down to the courthouse to physically?
Oh, no, you don't have to do that. If you could put your email in the chat, or if you could just call the courtroom, Mr. Flanagan will email you the report.
Great, I'll call the courtroom.
Okay, do you have the phone number?
I don't. If you could give that to me, I'm ready.
Okay, 965-2295.
Terrific. I'll do that as soon as.
Yeah, he'll email you the report. You don't have to come down and get it.
We'll see you on the 25th at 9 o'clock.
Okay, then everybody have a great day and stay safe.
Okay, you too.
All right. Bye now.